This is part 5, other ways to meet the ancillary requirement for a Texas non-compete. Another important way that a Texas company can try to meet the ancillary requirement is to tie a non-compete to the sale of the business. When I buy your business, I'm typically not just buying the physical assets, I'm also buying the goodwill of the business. To protect the buyer's legitimate interest in the goodwill, Texas courts will typically say that a non-compete tied to the sale of a business meets the ancillary requirement. A related way that a Texas company can try to meet the ancillary requirement is to tie the non-compete to some kind of equity ownership interest that an employee has in the company, such as stock options. That was the situation in the Marsh case decided by the Texas Supreme Court. The court held that the employer met the ancillary requirement by tying the non-compete to the employee's interest in company stock options. Before Marsh, the Texas Supreme Court had interpreted ancillary somewhat narrowly. The court had said that the consideration given for the non-compete had to give rise to the employer's interest in restraining the employee from competing. But Marsh did away with this give rise to requirement. Marsh interpreted ancillary more broadly to mean that the non-compete just has to be reasonably related to an interest worthy of protection. So in most cases, if you have a sale of a business or if you have employee stock options, the non-compete will probably satisfy the ancillary requirement. Next, you have to look at the reasonableness requirement, and I'll talk about that in part 6.